Public Defender Chelsea Vergils with and on behalf of Cyrano Johnson. Mr. Johnson, please state your name.
Cyrano Johnson.
I mispronounce your name every time, sir.
It's okay.
I apologize.
Thank you, Your Honor. Today is the time and date set for a probable cause conference. Regarding that, we are asking for an adjournment to show compliance with his bond conditions. I understand he's had a violation that we are prepared to deal with today.
All right.
Mr. Johnson is prepared to plead guilty to violating his bond by consuming alcohol on July 7th.
And I'll accept that. Before imposing any sentence regarding that, I'm going to ask this question. He presumably has indicated that he had O'Doul's. So my only question is, does your client wish to stick to that story, or does he wish to tell me the truth?
I believe that he would not be sticking to that story, that he would be stating that he consumed beer.
That's correct, Your Honor.
Then why'd you tell everybody O'Doul?
I had O'Doul's first, but I needed beer.
You had O'Doul?
Yeah. I don't look like what I'm going through.
No.
I had O'Doul's.
Are you
I had
tell me that? So did you tell them that?
Yes.
That you had O'Doul's first and then had beer?
Okay, pause right there. This is the moment the entire hearing shifts. What started as a routine bond violation just turned into a credibility crisis. In court, I omitted is just a softer way of saying I wasn't fully honest. And judges, they zero in on that because bond conditions aren't suggestions, they're court orders. Now, here's the real issue. It's not just the beer, it's the attempted spin. When a defendant minimizes instead of owning it, that signals risk. And risk is exactly what judges evaluate when deciding whether someone stays out of custody. Be honest, if you're the judge, are you more upset about the drinking or the half-truth? Drop your take in the comments.
Maybe I omitted the beers, but yes.
What?
I omitted the beers.
Hold it. You know what, sir? Don't play fast and loose.
I got you.
Story.
I consume alcohol.
I know that. You lied to them. Did you even have an O'Doul's that day?
Yes.
How many?
6.
And then how many beers?
2.
So why didn't you tell them that you had the beer?
I just omitted.
Pardon?
I just did.
Whew, that calculation wasn't just math, it was a judicial mic drop. The judge literally walked through the science to dismantle the story. 25 non-alcoholic beers in an hour, no bathroom break? That's not a defense, that's a logistical impossibility. Here's the legal error. When a judge believes someone intentionally misled pretrial services, that's bigger than the underlying violation. It goes directly to whether they can be trusted on bond. And trust is everything in pretrial release. Once credibility cracks, custody becomes very real. So let me ask you, do you think the judge already decided the bond fate right here? Or was there still a chance to recover?
Didn't. I was afraid of what might happen. I thought I could pass.
Yeah, I would be too. Because
Right.
you're violating your bond condition.
Indeed.
So, first of all, we did the calculation because the only story you gave is that you had O'Doul's. To get to the level that you were at, you would have had to have 25 O'Doul's in an hour
No, I didn't have
in
that.
order to reach that level.
Sure.
And could not have used the bathroom because you couldn't eliminate in order to get to that level. That's how stupid your story was. And now you can't even, you can't bring yourself to say that you were intentionally lying to them and attempting to mislead them. It was not just a simple omission. Counsel, what did you want me to do with this case?
In regarding the probable cause conference, we're asking for a 2-week adjournment so that he can show that he's going to comply with the court's orders. I
Well,
understand.
I don't think he's going to have a choice on that, quite frankly, Mr.
You're-
Allen.
We are asking for him to remain out of custody today. This would be his first bond violation. He is here to be honest with you, although the truth doesn't always make sense.
Really?
He is.
Really?
He's here.
No, he was not being honest. I asked him the question and then asked him the question of why didn't he tell them? And he couldn't even be honest about that. I'll let you go ahead with your argument, but I'm not buying any of that.
Your Honor, he is honest about the fact that he consumed alcohol, and he is very open to treatment. He understands that he has a substance issue and he wants to get help for that. Your Honor, he's a business owner. There's a lot of pressure on him. He provides for himself and his family. He also does volunteer work, not court ordered, just out of the goodness of his heart. He is open to treatment, substance abuse, counseling. He plans to seek that regardless of whether the court orders it or not. We're asking you to keep him out of custody with a scram tether. Again, this would be his first violation. And he is asking for the opportunity to show compliance while out of custody.
Anything from the people?
Your Honor, we do have some concern about Mr. Johnson's ability to comply with the bond conditions. As stated, this is his second offense. I think it's just a couple of years. We would note that in this case, he allegedly was not awake in a vehicle that was in the street with 2 guns on him, although he's only charged with 1 CCW. So we do have some concerns about whether he's able to comply with those bond conditions.
Anything else?
Your Honor, I just think that he would have a better opportunity to get the treatment and help that he needs out of custody.
He first has to admit that he has a problem.
I
The
do.
way that he does admit that is he stops lying. Defendant's bond at this time is revoked. Defendant's remanded.
Anna Mackey on behalf of Mr. Haywood, who is approaching to my right. Please state your name for the record.
Good morning, Your Honor. Devon Hayward.
Thank you.
Your Honor, I believe you reached a resolution in this matter.
You have. And it's here.
Perfect.
That's right. This is the one that, hang on a second. I just want to make sure this is the one that I looked at. All right. We have a plea form in this case that the defendant would be pleading to the charge of use of a controlled substance. I don't have, how come these forms aren't that hard to fill out?
Pardon?
How come I don't have the maximum penalty on here of what he's pleading to? Who did this? Mr. Childers? Mr. Childers, type. Childers, you know what? No, you know what? It's typed. Did you type it?
No, I did.
You didn't. Who did?
It was a group effort, but I'll take
I appreciate Ms. Mackey because she provided me with the basic love. This is I think we're both at fault here.
It just felt.
She provided me with a mostly typed out plea form. All I did was look at it, sign it, and send it back to her.
Because if it was up to me.
I fill these out myself. I
Correct.
appreciate it, Ms. Mackey doing my work for me. I'm not gonna, stop there.
Well, she had did it.
Yeah, and so we will.
I wasn't going to put a max penalty for my client.
What?
It felt wrong to like do that part. So I was like,
That hurt. I just couldn't write that. I couldn't type that part. What is the maximum penalty on the one? Pardon?
1 year.
1 year, 2,000. It was a group effort. I like how they all
that
sat
again.
there and tried to protect each other. All right. May I have him sworn?
Solemnly swear in the testimony you're about to give the truth, the whole truth. So if you got it.
I do.
State your name. Devon Haywood.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of use of a controlled substance. That's a misdemeanor, punishable by up to 1 year incarceration and $2,000 fine plus court costs. Do you understand that, sir?
I do, Your Honor.
Do you understand what a no contest plea is?
Yes, I do, Your Honor.
All right, two things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
I do.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
I understand.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
I do.
All right. Basis for the no contest plea?
Civil liability, Your Honor.
All right. And sir, to this charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct, sir?
Yes, sir, Your Honor.
You have any question regarding any of those rights?
No, sir, Your Honor.
All right. Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I am. I'm on probation for, explain the case.
Well, were you on probation at the time of this offense?
No, Your Honor.
All right.
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
All right. The court has been provided Washington County.
Now contrast that energy with this plea hearing. Notice the tone shift? Structured, methodical, rights explained one by one. That's how plea colloquies are supposed to go. The court has to make sure the defendant understands exactly what they're giving up. Trial rights, appeal rights, even the risk if they mess up before sentencing. And here's something important. A no contest plea isn't an admission of guilt, but for sentencing, it's treated the same as guilty. That distinction often matters for civil liability, which you heard referenced earlier. Two defendants, two very different courtroom vibes. One loses bond after credibility issues, the other keeps bond pending sentencing. Same courtroom, completely different outcomes. Which moment stood out to you the most, the bond revocation or the plea form drama? Let's talk about it.
Sheriff's Office report, and I've also reviewed that report for their case number 24-42704. Any objection to the court having reviewed that report?
Okay.
None from us, Your Honor.
All right. Sir, you also understand that if between the time I accept your plea, if I accept your plea, and the time of sentencing, if you commit misconduct as defined by the court rule, two things would occur. You would not be entitled to set aside your plea, and the court would not be bound by any sentence agreement and or evaluation of your case. You understand that, sir?
I do.
All right. Based upon the review of that report, the court does find that there is a sufficient factual basis in which the court could determine the defendant's guilt. Before I accept his plea, is counsel aware of any other promises, threats, or other inducements which have caused this plea?
Not be able to be.
None, Your Honor.
All right. Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
August 14th, 2025 at 10 a.m. in Judge Washington.
August 14th, 2025. What time?
10 a.m.
10 a.m. before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you. Thank you, sir. Court calls the case People versus Derek Stevens.